Hello everyone, and welcome to your Masters in Governance and Management. My name is Sandy, and today we'll be discussing Module 2, which is about business and corporate law. Today we're going to be discussing Module 2 with Dr. Franklin Kakia, who is a lawyer and an expert in the field, and will be also your lecturer for Module 2. Dr. Kakia, first of all, thank you for being with us today.
Thank you for the introduction.
No problem.
Happy to be here.
I just want to start off with an introductory question, as usual. So if you could help us define what is a contract?
Sure. So basically this question is quite a simple one at first. However, there are certain conditions which are prescribed by law which one must satisfy for there to be a valid contract enforceable by law. A contract basically is an agreement between two parties. Two parties which need to have the required capacity to enter into an agreement. When I talk about capacity, it's actually one of the conditions of a contract, and it means that they are legally capable of entering into an agreement with each other.
Okay.
A valid contract doesn't need to be necessarily in writing, it can also be verbal. However, this depends on the specific law which we are talking about. So for example, if we're talking about a commercial contract for a service, that service agreement need not be reduced in writing, it can be verbal. However, for example, if there is a lease agreement, a commercial lease agreement or a residential lease agreement, according to Maltese law, it requires it to be in writing. If it is not done in writing, it's actually null, we say ab initio, it means from the beginning. So that is a very basic introduction as to what a contract or an agreement is. Actually, sometimes I prefer using the word agreement rather than contract because it's easier to listen to if you go up to someone and tell them, let's agree on certain terms and conditions. It makes it a bit more amicable. Even though the word contract is actually the specific word specified by law. Before, I also mentioned that parties to enter into an agreement or a contract need to have legal capacity, and this is one of the conditions to have a valid contract. Capacity means that they have the mental capability of entering into agreement, meaning they know what they're entering into, and that they're not incapacitated at law. Unfortunately, this is the specific word mentioned in the law, that they are not incapacitated at law. Because, for example, it could be that they have committed a previous crime, for example, a fraud, and the court would have ordered their incapacitation at law so as not to enter into any future contracts. So they have to be capable at law. Also, they have to have the legal age to enter into a capacity. The legal age would be 18 years of age. However, in certain circumstances, there is certain contracts which may be entered even at a lower age, at the age of 16. You may enter into, if you are younger than that, however, you need the authority of your guardian or parents, depending on whatever is the case. Another important condition of an agreement is the consent required by both parties. When we speak about consent, it means that this is very closely interlinked with capacity. It means that the parties willfully are entering into this agreement, knowingly have knowledge of the conditions which they are entering to, and there is no element of coercion, meaning there's no ulterior force which is forcing them to enter into an agreement. They're entering into an agreement at their own free will, and that is consent. Okay. The other condition of an agreement is the subject matter, or causa. The subject matter of an agreement is that for example, if we're entering into a service agreement, the subject matter of the agreement is that I will be performing a service to you, or vice versa. And in exchange for that, you will be remunerating me for that service. That's a very basic subject matter. And the last condition for a valid contract is that there is a lawful consideration, meaning that the service which I am providing, I'm giving a constant example of a service agreement. There can be other commercial agreements, of course, but the lawful consideration means that the service which I am providing is lawful. For example, if I am selling drugs, that is not a lawful consideration. Therefore, the contract is null and void ab initio from the very start. And those are the four essential elements of an agreement. So therefore we have capacity, consent, subject matter or causa, and the lawful consideration. Just to move a step further, when it comes to the salient features of an agreement, we also look into the interpretation of contracts. Usually the court, or if there is an alternative dispute resolution, for example the arbitrator, would interpret the contract according to the spirit of the spirit of the parties. When we talk about spirit of the parties, what it means is that what is the intention of the parties when they have when they sat down and they started negotiating the terms and conditions of the agreement. And the judge or whoever is interpreting the contract needs to interpret the contract according to what the parties intended. And sometimes it may be difficult to identify what the parties intended, but that is when circumstantial evidence will come into place, and various other supporting documents and other kinds of evidence. But that is when it comes to interpretation of contracts. The judge will strictly interpret the contract as to what is intended between the two parties. Naturally, if there is dispute, which is the next point I'll be talking about, if there is dispute between the parties, they would generally resolve to either an amicable dispute resolution. So, for example, they would invoke an arbitrator, which is an outside court dispute resolution. If they can't reach an agreement, then the court will adjudge what is the best option, whether to terminate the contract or else enforce the contract terms accordingly. So, for example, if there is a service agreement, I am providing the service, but the other party is not paying me, the court, in case of a dispute, can enforce that agreement and bind the other party to pay the service required. Okay, and finally, with respect to this point, when it comes to breach of a contract and what are the remedies at law, usually this will be a specific clause mentioned in the agreement. So in case of material breach of any of the clauses of the agreement, there would be a specific clause which governs what would happen. So for example, there would be either exclusive jurisdiction, meaning that this dispute will be heard in front of a court at law in Malta, or the parties would choose to resort to arbitration. Arbitration is an alternative dispute resolution, which is faster, more efficient than the court. Okay. As well, the general acknowledgement is that court proceedings can take some time, and in order to not delay any dispute, parties would usually agree to resort to arbitration, for example. So that would, any breach of contracts or remedies would usually be catered for in the agreement. If they're not catered for that, not to worry, because remedies are offered as well by the civil code, by the Maltese civil code, and it would tell you that in case of certain material breaches of the contract, you may ask the court for a judgment and to resolve the dispute between the two parties as well. So that's the general introduction as to what a contract is.
Okay, thank you. All right, for my next question, I'd like to help us differentiate between a quasi-contract, a quasi-tort, and a tort.
Yes. So, as we said before, a contract is usually an agreement between two parties, whether verbal or non-verbal, meaning a written contract. There could be situations where an agreement is not really in place, but because of the circumstances, the judge can decipher certain elements of a contract. So just to give you an example, if I am living in a block of flats and I notice that the common areas are being deteriorated, out of my initiative, I make sure so that no more prejudice is caused to the tenants and to the building itself. I make sure that I make certain improvements, structural improvements to the common areas to ensure the safety of the people living in the common areas. That per se is a quasi-contract, because then I can, because I made sure that there are improvements to the common areas, I can actually sue the owners so that they compensate me for the services which I rendered. So there wasn't an actual agreement between the parties, but it's like it's an implicit or tacit agreement, which there are actually provisions in the law whereby such person doing those improvements is its own affair that would be compensated. Naturally, this doesn't mean that I can just do whatever I want and expect to be remunerated. There has to be certain proof that these structural changes were necessary to ensure that the common areas and that no one is prejudiced or as any other damage is caused. So that is a situation where there is a quasi-contract. Quasi-tort and tort are very intrinsically related. What tort actually means is fault. In fact, this tort, even though it's an English word, it's actually also a Maltese word, and it means fault. Whose fault is it? There are situations where it's no one's fault, it's no one's tort, and these were situations where there is an act of God. For example, if a lightning bolt hits a lamp and this lamp collapses on a car, that is fortuitous damage and that's an act of God. Okay. So that no one is really at fault, and they call it an act of God. It's not even God's fault, but that's the way it's the term used in the law. However, there could be also the court would make a step further and investigate. So I mentioned the example that a thunderbolt, a lightning bolt, hits a lamp. And you would say, okay, so it's an act of God. But were the health and safety regulations adhered to make sure that that particular lamp withstands a lightning bolt? If they weren't adhered to, then we can find responsibility. We can find who is responsible. So who is responsible to make sure that in the event of a lightning bolt hitting that lamp, that lamp could actually withstand lightning. So in that case, the court would investigate further as to see whose fault it was, or quasi-tort, because this situation where there's an act of God is quasi-tort.
Okay.
And then going a step further as well, quasi-tort also invokes elements of negligence.
Okay.
And there are various degrees. So there's contributory negligence, there's culpable negligence, and also gross negligence. When there is gross negligence, this would usually be very easily proved in court. If, for example, you are at a construction site and employees need to wear health and safety helmets for their own safety and of course to adhere to certain rules and regulations by law. If that particular employee is not wearing any safety equipment, that's gross negligence. However, not only gross negligence on his part, now we go into contributory negligence. Contributory negligence is when the person who should be responsible in making sure that his employees are adhering to health and safety regulations supervises and oversees that these actual health and safety regulations are adhered to by the employees. So the employee is negligent in not wearing the helmet, but the employer, was he making the necessary checks to ensure that his employees are wearing helmets at the place of work? So over there, there's contributory negligence. If an event occurs on site and which causes damage either to the person or to the surroundings, the court would analyze as well and would assess who was negligent in performing his or her duties. So in this case, we're seeing a spectrum of the two sides of the same coin: the employer, who's responsible for his employees, and the employee, who has a subjective responsibility in making sure to wear the helmet every day at work. Of course, I'm using an example. There could be other instances. Other instances of indirect responsibility, or we call it vicarious responsibility as well, is the parent and child relationship. If, for example, the child mischievously decides to break in a house, or decides to spray paint a particular household, whose responsibility is that? In that case, there is vicarious liability, and the responsibility is of the parents or the legal guardians in the absence of parents. So that's another degree of whose tort it is, whose fault it is. Also, the law also mentions specifically pets and their owners. So if, for example, you have a dog and you're walking the dog not on a leash, and this dog decides to attack someone and causes damage, the owner of that particular pet or whatever animal would be responsible as well in that particular case. So this is another example where indirect and vicarious liability tort is actually catered for in the law. Just to as well clarify a bit more, these when we speak about contracts and torts, quasi-torts or quasi-contracts, they fall under the same heading of the law, which is wholly referred to as obligations.
Okay.
There are obligations which are reduced either verbally on writing or in writing, for example, in the case of contracts, and then there are obligations which stem from particular situations, everyday situations, day-to-day situations, which happen on a daily basis. I can give you another example: driving your own car. Driving, as you know, driving is one of the highest risky activities which can cause damage on a daily basis. When you're driving your car, you have to make sure that you understand the liability at hand. So if you are drinking and driving and you hit someone, that is your responsibility, and the consequences will of course be will ensue in that respect. So that's another example as well of vicarious liability. Finally, as well, this is linked to tort as well. Another example is libel suits or responsibility as to what you write, or defamation. When you write something about someone, or for example, it could be that you are on TV and you accuse someone of false or could be true as well, activity that person undergoes. This media and defamation was specifically catered in the criminal code.
Okay.
However, this was repealed from the criminal code, and a new specific kind of act called the Media and Defamation Act was drawn up, and it's actually law as of recently, 2018. This is another responsibility, more of a global responsibility. When you write something publicly, or you say something publicly, when I say it's publicly, not just via a video conference, for example, or on a broadcasting TV program, but also on social media platforms, be it LinkedIn, being Facebook, be it Instagram, you are responsible for what you say. And if damage ensues, now also in Malta we have also as well the concept of moral damages as well. This is something which is in our law and judges have opined on as well. So there need not be actual quantifiable damage, also moral damages. There's a formula as to which you can quantify moral damages. If with your words, with what you say, you are causing damage, the court will, or the person who has been aggrieved by what you say, can seek compensation either civilly, so there'll be separate proceedings in a civil court, or else criminally, and that will be driven by the executive being the police. So in that case, also damage can ensue, which is tortious damage. So I hope that answers this question.
Okay, and for my next question, if you could help us define what is a principal and how are commercial agents governed?
Sure. So basically, the relationship between a principal and an agent is governed by the commercial code, which is a Maltese, a bit of an old code, which codified and made sure that this relationship works in the most diligent way. The agent, what's important to keep in mind is that principals, whenever they instruct someone to act on their behalf, remain responsible for the actions of the agents. So that means anything that the agent does or says will be contracting on behalf of his principal. So there's a certain element of, once again, indirect liability and indirect responsibility when it comes to this relationship. This relationship is very similar as well to a parent and child liability. Okay. As we had said before, any actions which the child carries out, the parents will be responsible for that. And same is the relationship between a principal and a commercial agent. Of course, you can reduce in writing that an agent is an independent agent. So what that means is that the agent is not dependent on the instructions of the principals, and the agent can act on his own free will. This, of course, depends on what the agreement is in place. But generally, if there is no such agreement, such relationship is governed by the commercial code. Having said that as well, as most of us should be aware, we're part of the European Union, and the European Parliament would generally agree on the text of a certain particular directive, and then the directive is transposed into Maltese law. Okay. There is the Principal Commercial Agent Directive, which has been transposed in Maltese law, which gives further protection to the principal when it comes to the actions of the agent. And this is thanks to the European law, which was transposed.
And how are consumer rights established under Malta law?
Sure. So the law generally tries to protect the weaker party in all circumstances, be it employment, be it commercial terms, And this is a particular scenario where the consumer is construed as the weaker party. Why? Because most of the times consumers would not be expert in a particular product. So for example, and that's why there are warranties in place. So for example, if I decide I'm a consumer and I decide to buy an oven, I am not an expert in oven or other appliances of the sort. So I would rely on who is selling me that particular product. And that's why there are warranties in place, that if there is any latent defects, there'll be a 2-year warranty, for example, where the consumer has the right to replace or have the product repaired. So once again, the European Union gave a lot of protection by way of legislation and directives to consumers because they are the weaker parties, and these were transposed into Maltese law. And the main body of legislation which assists and protects consumers is the Consumer Affairs Act. Okay. The Consumer Affairs Act not only stipulates what the rights of the consumers are, so for example, having a 2-year warranty on a particular product, that's a right of the consumer. But it also regulates the behavior of the sellers. Meaning, if there is a particular product which I want to sell, I have to make sure that I give enough warranty on that particular product to the consumer to protect further the consumer. Furthermore, as well, this Consumer Affairs Act sets up a very important body, which is the Malta Consumer Affairs Authority. This body, once again, it's the implementation body of the Consumer Affairs Act. And it gives an added protection to any consumer. Any consumer who feels aggrieved by a particular seller or trader can file a complaint with this body, and this body, the authority, will take the necessary action against that particular trader. And also there is as well a tribunal which is set up to hear any grievances that occur between a seller and a consumer.
Okay, all right. So my next question is, how is the relationship between an employer and an employee governed in Malta?
So employment law is a very vast and very wide-encompassing piece of legislation. Employment law of course, is a very important piece of legislation because it governs our daily life. The main body of legislation is the Employment and Industrial Relations Act. And this has been amended several times, once again, because of our introduction within the European Union. And linking to the previous question, because the employee is seen as the weaker party, the European Union wanted to make sure that the employee is safeguarded. Of course, the employer is safeguarded as well, because what the law establishes what the rights of the employer are and what the rights of the employee are as well. And like that, everything is transparent and all the parties know what they're going at. So apart from the fact that this links to our first question, what is a contract? So an employment relationship is generally governed by an employment contract. And all the rights and the conditions of employment which are in the agreement governs the relationship between an employer and an employee. However, and this is something which is very spectacular of the law, if there is any missing condition in the employment agreement, or there is a condition which is less favorable to the employee, the law kicks in and takes over the agreement. So basically, it gives an added protection to the employee in that it can resolve to what the law says. Apart from that as well, there is the Industrial Tribunal. The Industrial Tribunal is a small tribunal to listen to cases predominantly on unfair dismissal. So when an employee is fired because there are no good and sufficient grounds, that's unfair dismissal, and the employee can take action against his previous employer in this tribunal. The idea of setting up a small tribunal as opposed to referring the case to a bigger court was that cases are heard more in a more efficient and more speedy way.
And what about harassment and discrimination?
So as we have developed into this field, what came about was the importance of eliminating discrimination, whether direct and indirect, and that and actually non-discrimination is embedded in our constitution, and harassment at the place of work. And this was a very sensitive and important topic that was included in the new Employment and Industrial Relations Act. As most of us are aware, non-discrimination, especially at work, needs to be properly adhered to. So basically you can't discriminate as to who to engage or offer less favourable services, less favourable conditions of work if according to their gender or according to their political affiliations or according to their sexual orientation, for example. These conditions, non-discrimination, is a salient feature, especially even though sometimes we don't actually find it in agreements on discrimination, but it is so to say implicit that employers manage the place of work on a non-discriminatory basis. Same with harassment as well. When we speak about harassment, we're not only speaking about sexual harassment, but also if, for example, there is a particular employee and employer which is causing prejudice to other employees, that is considered as well harassment. Also, certain verbal aggressiveness, for example, or verbal aggression, that can be considered as harassment as well. And by virtue of the directives transposed into the Maltese law, employees are given added protection also when it comes to non-discrimination and harassment at the place of work.
Okay, thank you for that. And so for my last question is, how is a company formed here in Malta? And what law governs the formation of companies? Okay,
so the main piece of legislation when it comes to companies incorporated in Malta is the Companies Act. The Companies Act is basically the Bible when it comes to companies registered with the Registry of Companies here in Malta, which is also set up, or its composition is as well codified in the Companies Act. So a company is formed upon its registration, meaning when the memorandum and articles of association are submitted to the registrar for review, and the registrar registers them and uploads them on the official registry website, they are made publicly available, and it is at that point that the company becomes a Maltese company and achieves separate legal personality. So just to go a step back, the memorandum and articles of association of the company are the constitution of a company. So in the memorandum there will be who is the company secretary, for example, who are the directors, what is the share capital of the company. Everything you know about the company will be there. How meetings are governed will be in the article. So for example, how often, what is the quorum for a particular board of directors meeting? What is the quorum and what are the procedure of a shareholders meeting? Notices, by when does a notice need to be issued to inform the shareholders or the directors of a particular meeting. Everything will be governed in the Memorandum and Articles of Association. So, as I said before, the M&As, Memorandum and Articles of Association, are submitted to the registry, they're uploaded on the official website, and it is then that the company achieves separate legal personality. What does that mean? This is a legal fiction which was created with the case of Solomon and Solomon, which is an old UK case. And basically it says that a company is a separate person to its shareholders, meaning that the company achieves legal personality, it has a right to sue, it has a right to be sued, can own property, it can enter into agreements. It's a new legal person. It's a new person created from scratch, and that's the legal fiction, which sometimes can be hard to understand. But basically, any creditor or any person who wants to sue a particular company has to do it through the company and not the shareholders. The shareholders' patrimony, the shareholders' assets are independent of the company. The shareholders' liability with respect to the company is only with the amount of unpaid shares, because shares can be fully paid up or not fully paid up. Usually they are fully paid up. So for example, I am a shareholder and I purchase 20 shares of €1 each. I pay €20, for example, and that's a share capital which is fully paid up. Not fully paid up, meaning I pay €10 instead of 20. And so therefore, me as a shareholder, my liability is only restricted to that unpaid share. In my example, €10. Any other creditor cannot really sue the shareholder or shareholders for contracts which have been contracted by the company, because the company is a separate person to its shareholder, and is the legal fiction. It protects actually the shareholders behind the company. You might ask as well, but a second, the company can't contract. Someone has to represent the company. And as a matter of fact, there's a clause in the memorandum of association of a company which says who are the people that legally and judicially, so in court, who will represent the company. Generally, these would be the directors of the company. However, they can be separate persons. This is important to keep in mind, that directors are very, very much responsible for the general administration and management of the company. We say, in colloquial terms, where does the mind and management of the company occur? And usually it's where meetings are held and where resolutions are taken. So for example, if there's a board of directors meeting being held here in Malta, the mind and management of the company is in Malta, and it's taken by the directors, because they decide who the affairs, what the affairs of the company are, and day-to-day management. So that is when a general introduction of how a company is formed here in Malta. Of course, as we said before, the main piece of legislation is the Companies Act. There are, however, various other subsidiary legislations, we call them, which one would need to look at when it comes to particular circumstances. For example, just give an offhand example, incorporated cell companies are particular types of companies that are governed by a subsidiary legislation. Other open-ended CCAF, we call them, companies are usually used for funds, are as well governed by a subsidiary legislation. So you would have the main provisions in the Companies Act, but then you'd need to look at any subsidiary legislation which governs that particular instance. Apart from that as well, apart from the fact that how the company is formed, one would also need to understand the various offices that a company has. So the various offices, I'm talking about the directors. They are officials of the company, and the responsibility is huge. One of them is, for example, wrongful trading. There is a particular provision in the law that if the directors knew or ought to have known, so there's a certain element of further degree, they ought to have known that the company was not of good standing, and there wasn't enough assets to meet its liabilities, and it kept on trading that particular companies, then the responsibility and wrongful trading occurs because the directors were not diligent enough. The director's responsibility is one of, we call it bonus pater familias, meaning the affairs of the company has to be taken care of as if I am a father taking care of my children. There's a very high element of responsibility when it comes to the affairs of the company, because of course the directors own their interest to the shareholders of the company, and they have to make sure that they report back to the shareholders, to the owners of the company. Also, other officials which are good to mention are the company secretary. The company secretary is the person who takes care of meetings, for example, of notifying the relevant parties, the shareholders of the meetings, making sure that any new members of the company are registered in the register of members, making sure that all registers are in place as well. So as well, the company secretary has quite a role in this case. And another important official is the auditor of the company, the accounts. The accounts of a company, by law, by Maltese law at least, they have to be audited by a Maltese auditor. So that means that the auditor has to ensure that the accounts reflect a true statement of affairs of the company. When it comes not only to financial matters, but also anything which the auditor deems that's not it's not right. So, for example, if a particular company is trading in gaming and providing games to various players, the auditor would need to ensure, and he is obliged by law to ensure, to inform the directors that, listen, this company is operating without a license and it needs a license. So the responsibility of auditors as well is something which is very onerous, and it's a very, very important function for when it comes to the company. Or another example for for example, I mentioned gaming, the gaming sector, but also if the company is in the investment sector, for example, in that case, the auditor has a legal obligation to inform directors that, listen, if the company wants to operate in the investment field, that investment requires, that particular activity requires a license issued by the Malta Financial Services Authority. So that is another important role when it comes to companies here in Malta.
Okay, so Dr. Kahia, that pretty much concludes the questions I have for you today. I'd like to thank you for sharing your knowledge and experience with us, and thanks for your time.
Thank you, actually.
So there you have it, students. We spoke about today business and corporate law. We discussed various topics. We defined the contract, the quasi-contract, the quasi-tort, and the tort. And we also looked into different laws, amongst which were the Employment and Industrial Relations Act, as well as the Companies Act. That's it for today, and see you next time.